Welcome back to another episode of Dissecting Insurance, and I'm your host Shubhajit. Now, before I start this episode, let me express my sincere gratitude for the love and support shown to our first episode. In fact, to be very honest, I was quite nervous how this podcast would be received. But after releasing, the love, support, and encouragement I got was truly overwhelming and honestly beyond my expectation. So, a big thanks to all the listeners and well wishers, and we will try our best to create good content on insurance. And please keep showing your love and support to Dissecting Insurance. So, continuing the series on marine insurance, once again we have with us Mr. Basudev Sanyal sir. Many of you already know him from our first episode, but for the first time listeners of this podcast, let me share a brief introduction. Basudev sir is the Deputy General Manager of a leading PSU general insurance company and have an experience of almost 34 years in general insurance industry. He has headed various operational offices and worked across multiple technical departments such as marine, health, miscellaneous, motor, both as an underwriter and as a claim settling authority. Currently, he is serving his company in the corporate head office. Besides this, Basudev sir is a fellow of Insurance Institute of India, and apart from his daily work, he enjoys deep diving into various aspects of insurance. This passion of his has led him to author multiple technical articles which have been published in various journals. And to say he has been an instrumental in making this podcast would be an understatement. In fact, he has been a pillar of support in this endeavor. So welcome back Basudev sir. And before we proceed to this episode, let me first congratulate you for the love and appreciation you received for the first episode. People really liked your last episode and want to hear more from you. How do you feel about this, sir? Did you expect this kind of response?
Thank you, Shubhajit. And whatever support the first episode has received, for that a lot of credit has to go to you.
Thank you, sir.
And frankly speaking, I was not expecting a great response in terms of numbers, considering that the topic of the first episode was of an intricate nature which would normally appeal only to a niche segment of listeners. Considering this, I can say overall the response has been beyond my expectations.
Thank you, sir. And like we discussed in one of our informal meetings, the support basically vindicated the fact that there is a demand and there is a market for this kind of technical content. So I think we are in the right track, and I hope our listeners will enjoy this episode too. So the title of our second episode on this marine series is Piracy and Ransom, to pay or not to pay, and other questions in marine insurance. And speaking about crimes on sea, the very first thing that comes to our mind is the myth of a pirate, personified by characters like Long John Silver from the celebrated book Treasure Island by R.L. Stevenson, or it may be the colorful Captain Jack Sparrow from the movie Pirates of Caribbean. Romantic image of piracy perpetuated in our minds through various literary works and cinema is, however, far from reality. In reality, piracy is not something to romanticize about. Rather, it is a very grave issue and has resulted in significant loss of life and money. And it is something that has been going on for ages, with earliest documented evidence dating back to the time of Pharaoh Akhenaten, 1350 BC. So, my first question to Basudev sir would be, what is the actual impact of piracy? If you can give us the real picture.
At the outset, let me make it clear that, like in our first episode, there are going to be references to British court judgments, as historically these have laid the foundation for insurance law and marine insurance law. The principles laid down in these judgments have had universal application and are widely accepted, and even by Indian courts. Coming to piracy, it is unfortunate that many people outside the maritime and insurance industries do not realize that piracy has been and remains a costly peril even in the 21st century. Global insurer Zurich estimates annual cost of piracy to the global economy at $12 billion a year. In its 2022 Safety and Shipping Review, Another global insurer, Alliance, reports that piracy comes only behind machinery damage or failure, collision and contact in terms of number of loss-causing incidents for the 10-year period from 2013 to 2022. Also, the occurrence of piracy has a significant deterrent effect on international trade. We know that around 90% of all international trade is through sea transport. For every additional 10 additional piracy attacks, it has been estimated that bilateral trade decreases by 1.5%, quite significant. Piracy was at its peak during the years from 2009 to 2011, when there were on an average 430 incidents of piracy every year, and of these, 30% originated in and around Somalia. The number of prisoners taken by pirates numbered 645 in 2010 and 555 in 2011, as per a report by the US-based One Earth Future Foundation and International Maritime Bureau. Further, Somalian pirates seizing Indian Ocean ships were responsible for at least 35 hostage deaths in 2011. Of course, fortunately, since then there has been a significant reduction in the number of piracy incidents, with 132 such incidents in 2021, 115 in 2022, and 65 incidents reported in the first half of 2023. However, the Singapore Straits still remain an area of concern, and there was a significant 25% increase in reported incidents in these congested waters for the first half of 2023 compared to the same period last year.
So it's quite evident, sir, that piracy is still a very major concern, although it is somewhat decreasing nowadays. So now coming to piracy incidental to maritime adventure, sir, is there any definition of piracy in our insurance laws?
Before considering the definition under insurance laws, let us have a glance at the definitions under international law. Both the United Nations International Maritime Organization, or IMO, and the International Maritime Bureau, or IMB, currently use the definition of piracy as described in Article 101 of the United Nations Convention on the Law of the Sea, UNCLOS, which defines piracy as A. Any illegal acts of violence or detention, or any act of depredation committed for private ends by the crew or the passengers of a private ship or a private aircraft, and directed 1. On the high seas against another ship or aircraft, or against persons or property on board such ship or aircraft. 2. Against a ship, aircraft, persons or property in a place outside the jurisdiction of any state. B. Any act of voluntary participation in the operation of a ship or of an aircraft with knowledge of facts making it a pirate ship or aircraft. And C. Any act of inciting or of intentionally facilitating an act described in subparagraph A or B. According to this definition, piracy applicable to sea is limited to acts outside the jurisdiction of the coastal waters of a state. This means that any case of violence against ships occurring in the territorial waters of states is outside the jurisdiction of this definition. This definition also excludes acts of maritime terrorism, as only private objectives are included in it. Now coming to insurance laws, we can observe that in section 2 subsection E of the Marine Insurance Act 1963, which corresponds to section 3 subsection C of UK Marine Insurance Act 1906, the term pirates is included as one of the perils consequent on or incidental to the navigation of the sea. The term also finds a place in Rule 8 for the construction of the policy contained in Schedule 1 of the Marine Insurance Act, both the Indian and the UK versions, wherein it is stated to include passengers who mutiny and rioters who attack the ship from the shore. This definition, however, seems anachronistic and inadequate under the present scenario. For more clarity on this subject, we can look at a landmark case, Republic of Bolivia versus Indemnity Mutual Marine Assurance Company Limited, decided in 1909, where the court had the opportunity to interpret the meaning of the word piracy as an insured peril. It was stated in the judgment that, and I quote, "The word pirates, as used in the policy, must be construed in its popular sense, and in that sense it meant persons who plunder indiscriminately for their private gain, not persons who simply operate against the property of a particular state for a public end." Unquote. This judgment established that for the purpose of marine insurance, a pirate must operate for personal greed, a requirement now prevalent in international law. We may next refer to another landmark case, the case of Athens Maritime Enterprises Corporation versus Hellenic Mutual War Risk Association Bermuda Limited, popularly known as the Andreas Lomas case. This was decided in 1982. In this case, armed men came on board the ship with intentions to steal. However, they did not meet with any resistance and they managed to complete the theft without resorting to any force. The crime of theft was committed within the territorial waters and within the port limits. In the judgment for this case, it was held that, and I quote, "Theft without force or a threat of force is not a piracy under a policy of marine insurance." And further, again I quote, "Piracy is not committed by stealth." Unquote. On territorial jurisdiction for piracy, the judge opined that, and I quote, "I see no reason to limit piracy to acts outside territorial waters. In the context of an insurance policy, if a ship is, in the ordinary meaning of the phrase, at sea, or if the attack upon her can be described as a maritime offense, then for the business purposes of a policy of insurance, she is, in my judgment, in a place where piracy can be committed." Unquote. Following the Andreas Lomas case, it has been generally accepted that piracy must also be accompanied by violence at the moment of appropriation, and, unlike international law, marine insurance law extends acts of piracy not only on the high seas but also in territorial waters.
So it is obvious that the act of piracy has the potential to cause loss both to cargo and ship. And therefore, could you dwell on the coverage for piracy under marine policy and specifically under our standard international clauses, sir?
Until 1937, piracy was one of the named insured perils in the combined Lloyd's hull and cargo policy, popularly known as SG policy. Following the Spanish Civil War, piracy as a peril was removed from the standard policies and granted coverage under insurance for war perils. Later on, piracy was again shifted from war perils to marine in both cargo and hull around 1982-83. Now, Institute War and Strike Clauses, hulls, that is time 1983, expressly excludes piracy, vide clause 4.1.7 with the proviso that this exclusion shall not affect the coverage under clause 1.4 for loss or damage to the vessel caused by strikers, locked out workmen or persons taking part in labor disturbances, riots or civil commotions. For cargo insurance under ICCA 2009, that is all risk cover, clause 6.2 provides as follows: "In no case shall this insurance cover loss, damage or expenses caused by 6.2 capture, seizure, arrest, restraint or detainment, piracy excepted under brackets, most importantly, and the consequences thereof or any attempt thereat." This implies that piracy is not an excluded cause under clause 6.2 and is covered under the all risk cover afforded by ICCA. However, it is to be noted that in ICC B and C, not only is piracy absent as one of the named perils in the risk covered clause, but further in clause 6, the words quote unquote piracy accepted are not present, which is a clear indication that piracy is not a peril covered under either ICC-B or ICC-C. Piracy is also not one of the perils covered under Institute War Clauses Cargo and Institute Strike Clauses Cargo.
So, sir, you mentioned earlier that the UN definition of piracy does not include terrorism. Now, it would be interesting to know what are the differences between terrorism and piracy. In fact, if we draw a parallel to the very unfortunate attacks of September 11, suppose pirates or anyone else takes operational possession of a vessel on sea and uses it for violent means, will it be considered as an act of terrorism or as an act of piracy?
Well, before going on to the differences between piracy and terrorism, let us look at what actually terrorism is. Unfortunately, terror attacks on sea are not entirely unheard of, and two incidents that readily come to mind both happened in Yemen. In October 2000, two terrorists linked to Al-Qaeda used a modified dinghy packed with explosives to blow a hole in the destroyer USS Cole while it was in the port of Aden. 17 sailors were killed and 40 wounded, with estimated damages of US dollars 250 million to the United States owned ship. 2 years later, in October 2002, again in the Gulf of Aden, Al-Qaeda attacked the French oil tanker Limburg. The modus operandi being the same, a small dinghy laden with explosives was rammed against the vessel, and there was considerable damage to the vessel and cargo, apart from the death of one crew member and injuries to several others. To get an insurance definition of terrorism, we have to look at the revised Institute Cargo Clauses 2009, wherein Clause 7, that is an exclusion clause, provides that, and I quote, "In no case shall this insurance cover loss or damage or expense caused by any act of terrorism, being an act of any person acting on or behalf of or in connection with any organization which carries out activities directed towards the overthrowing or influencing by force or violence of any government, whether or not legally constituted," and 7.4, "caused by any person acting from a political, ideological or religious motive." In international law, unfortunately, there is no universally accepted definition of terrorism. However, the United Nations Security Council, in its resolution of October 2004, stated that terrorist acts, and I quote, "criminal acts including against civilians committed with the intent to cause death or serious bodily injury or taking of hostages with the purpose to provoke a state of terror in the general public or in a group of persons or particular persons, intimidate a population or compel a government or an international organization to do or abstain from doing any act," unquote. The Security Council further affirms that such acts are, quote, "under no circumstances justifiable by considerations of a political, philosophical, ideological, racial, ethnic, religious or other similar nature," unquote. In India, Section 15 of the Unlawful Activities Prevention Act 1967, UAPA, states that a terrorist act is, quote, "any act with intent to threaten or likely to threaten the unity, integrity, security or sovereignty of India, or with the intent to strike terror or likely to strike terror in the people or any section of the people in India or any foreign country." Coming to the demarcation between piracy and terrorism, this was explicitly stated in the case of Republic of Bolivia versus Indemnity Mutual Marine Assurance Company Limited, which we have already referred earlier, a 1909 case. In this judgment, a quote from Hall's international law was referred, which said as under, "Besides, though the absence of competent authority is the test of piracy, its essence consists in the pursuit of private as contrasted with public ends," unquote. The clearest distinguishing feature between pirates and terrorists is thus in their motives or intentions, mostly financial in the case of pirates and political or ideological in the case of terrorists. However, there may be other differences between the two, like for instance in their tactics, in the selection of targets, and in their modus operandi.
So even though primarily both of them uses violence as their means to achieve their goal, one has a private goal and another has a public goal, which I think basically differentiates the two.
Yeah, you're right.
Now, sir, let's discuss seizing of goods. From the point of view of the owner of the goods, once pirate takes possession of the good, it may be considered as a total loss or a constructive total loss. I'm saying this because even though the goods are physically not destroyed, it is also not under the possession or control of its owner. So how does marine insurance respond to this situation? Can the insured claim for a total loss in this scenario?
What you are essentially asking is whether seizure of goods in a ship captured by pirates results in an immediate total loss under a marine cargo policy which covers piracy.
Yes, sir. I think that is the question here.
Well, this question, along with other related issues, was put before the courts in the case of Macefield AG versus Amlin Corporate Member Limited, decided in 2011. A very important and significant judgment, in which the vessel Bunga Melati Dua was captured in the Gulf of Eden by Somali pirates while carrying cargo belonging to the claimant Macefield. Negotiations for the payment of a ransom to which the claimant was not a party were commenced by the vessel's owners around a month after the seizure. While negotiations for the release of ship and cargo were continuing, the claimant cargo owners tendered a notice of abandonment to their insurers, which was declined. Within about 10 days from this notice of abandonment, a ransom was agreed with the pirates and paid. The ship, crew and cargo were subsequently released. Despite the cargo, admittedly with its economic value diminished, being subsequently restored to them, the claimant Macefield nonetheless chose to claim under their all-risk policy, which incorporated the ICCA clause. It was the claimant's primary case that on the capture of the vessel by the pirates and its removal into Somali waters, their cargo became an actual total loss, that is an ATL, under section 57 subsection 1 of the Marine Insurance Act 1906. Same section in MI Act 1963 as well. The assured claimed that they had become irretrievably deprived of the cargo. In the alternative, the claimant also argued that there had been a constructive total loss or CTL under section 60 subsection 1 of the Marine Insurance Act, in that the vessel and cargo had been reasonably abandoned on account of its ATL appearing to be unavoidable. They also contended that for the purpose of determining whether the cargo could probably or properly be considered to be irretrievable, and in considering the prospects of recovery, the payment of ransom to pirates could not be taken into account, as this was contrary to public policy, even though not illegal. The High Court in the case considered essentially three issues. One, whether or not the capture of cargo by the pirates was an actual total loss in spite of the possibility of recovery by the payment of ransom. Two, whether the event could be considered a constructive total loss. And three, whether or not the payment of ransom constitutes a breach of public policy. In determining the ATL claim, the court noted that there was unchallenged authority confirming that for the purpose of establishing irretrievable deprivation and therefore actual total loss under section 57 subsection 1 of the Act, the assured must show that recovery is impossible. Given the history of previous cases of capture by Somali pirates, there was ample evidence before the court, which was also conceded by the claimant, that in reality there was a reasonable hope and likelihood that the ship and cargo would be recovered by payment of a ransom. On the claim for constructive total loss, the High Court held that in light of the assured's knowledge of prospects of recovery of the cargo, the subject matter insured cannot be considered as being abundant on account of its actual total loss appearing unavoidable. The High Court, having dismissed the claim on both the grounds, the assured appeal, this time confining its claim to actual total loss only. The argument of the claimant on appeal rested on the case of Dean versus Hornby, decided in 1854. In this case, a vessel had been captured by pirates and recaptured by an English warship afterwards. The court had unanimously held that a capture by pirates would be treated as a total loss. Furthermore, the court in the case of Kuwait Airways Corporation versus Kuwait Insurance Company, decided in 1996, referred to Dean versus Hornby and held that, and I quote, in case of capture, because the intent is from the first to take away dominion over a ship, there is an actual total loss straight away, even though later there may be a recovery, unquote. The Court of Appeal in the Masefield case, however, held the view that there is no rule of law that piratical capture constitutes an actual total loss per se. A very significant observation by the sole arbitrator Michael Kerr QC, who later became a judge of the Court of Appeals, in Dawson's Field 1972, was quoted in the Masefield judgment, in which it is said that, and I quote, deprivation of possession as such was not an insured peril, let alone a term of art to describe a case of total loss, unquote. Dean versus Hornby was distinguished by the Court of Appeals as a case referring to the capture of a vessel as a prize ship. Piratical seizure may amount to an ATL in circumstances where the pirates escape with their prize for their own use and there is no prospect whatever of finding or recovering the vessel or cargo. Quoting from the Court of Appeals in the Masefield case, and I quote, piratical seizure in the circumstances of this case, where there was not only a chance but a strong likelihood that payment of a ransom of a comparatively small sum relative to the value of the vessel and her cargo would secure recovery of both, was not an actual total loss. In my humble opinion, however, this wait and see approach advocated in the Masefield case, though apparently seeming pragmatic, creates a host of uncertainties for the insured cargo owner. It has been actually criticized as being contrary to a large body of previous decisions. For instance, the House of Lords judgment in 1908 in the case of Anderson versus Martin. It also leaves many unanswered questions, the most important of them being at which point of time can an insured expect to make a claim for compensation for total loss under his policy for loss of possession for cargo.
The insured claimed for a ATL and CTL, but his actual loss was a partial one. So, sir, why do you think he did not lodge a partial loss claim then?
Yes, it seems at first surprising that he did not claim for partial loss in view of the diminution of its value of the cargo. However, there could be two probable causes for this. One, there had been no physical loss, which is a prerequisite for a claim under a maritime policy on cargo. And two, even if there was a loss, proximate cause of it would probably be held to be delay in getting the goods to the market for sale. And delay, is an excluded peril under a marine policy.
So, sir, one of the issues framed by the High Court was that of the payment of ransom. And it would be interesting to know how it was addressed by the courts. The moot issues, according to me here, are whether ransom is legal and ethical.
It is increasingly seen that pirates are no longer interested in capture of the goods from vessels. They have changed their approach to seizing the vessels and demanding ransom for release. Most of the times, the ransom that pirates request is less than the ship's value, and hence most of the ship owners are inclined to pay the ransom in order to save the vessel, cargo, and the crew. Reverting back to the Masefield versus Amblin case, we observe that the claimant argued that the payment of ransom was undesirable from the point of view of public interest, and it could not be an insured's duty to pay a ransom demand. The property in question must be irretrievably lost, where the only means of recovery was by an act which an insured could not reasonably be expected or required to do, being an act against public policy. However, in response, the Court of Appeal contended that the occurrence of an actual total loss was a matter of fact only, and stated, and I quote, that there may be no duty to make a ransom payment did not turn a potential total loss which may be averted by the payment of ransom into an actual total loss, unquote. Both the High Court and the Court of Appeal opined that payment of ransom was in fact not illegal under English law, given that there was no legislation outlawing it, and instead there were decisions like the majority opinion expressed by the Court of Appeal in Royal Wascalis versus Mountain, decided in 1999, that held that ransom payments could be recoverable as sue and labor expenses. Moreover, it was observed by the courts that there was no evidence of ransom payments being held to be illegal anywhere in the world. The Court of Appeal further cited the guidance in 1938 established by Lord Atkin in Fender versus St. John Mildmay, in which his lordship, referring to the doctrine of public policy, said that, and I quote, the doctrine should only be invoked in clear cases in which the harm to the public is substantially incontestable and does not depend upon the idiosyncratic inferences of a few judicial minds, unquote. Interestingly, almost exactly the same sentiments were expressed in the 1959 judgment of the Indian Supreme Court in the case of Gherulal versus Mahadev Das, where it said that public policy was an elusive concept and should be invoked in clear and incontestable cases of harm to the public. It is not that ethical arguments against ransom payments were not made, but the court observed that there was a curious degree of complicity between pirates who on the one hand threaten the liberty of vessel crew and demand ransom payments at levels which industry and commerce can afford, and the world of government who participate in protective naval operations but on the whole are reluctant positively to combat the pirates with force. In these quote-unquote morally muddled waters, ransom payments exist as a reality for parties interested in marine adventure. It is important to point out here that courts drew a distinction between pirates and terrorists, indicating that there is international consensus that negotiations with or any funding of terrorists may be a breach of public interest. In the Indian context, it can be pointed out that in 2011, the Madhya Pradesh High Court, in the case of Commissioner of Income Tax versus Messrs. Khemchand Motilal Jain, held that while kidnapping a person for ransom is an offence under Section 365A of the IPC, nowhere in law it is provided that if a ransom is paid to save the life of a person, it will amount to an offence.
So another related question arises, whether ransom payments are recoverable under a marine policy. If so, under what account?
Having acknowledged the reality of ransom, you have turned the spotlight on a very important area, that of the treatment of ransom under marine policies, particularly under marine cargo insurance policies. We need to understand that in a piracy situation, the cargo owner is not at a very advantageous position, as he is not involved in the negotiations and consequently his fate lies at the mercy of the ship owner. Further, while the ransom demanded may be a fraction of the hull value, it could be in many instances more than the value of an individual cargo. What would be the situation, one may ask, if the insured or the owner of the cargo had contributed to the ransom paid in the Macefield case? Would that payment be recoverable as a sue and labor payment, for instance? Arnold, the authority on marine insurance to which most courts depend upon, makes the position very clear when he states that, and I quote, there appears to be little doubt that where a payment which is not illegal under any relevant law is made to secure the release of property, this can be recovered even though the persons demanding the payment are not acting lawfully in doing so, unquote. Let us look at the duty of the assured clause, or clause 16 of the ICCA, which clarifies the matter further, when it states that, quote, it is the duty of the assured and their servants and agents in respect of loss recoverable hereunder, 16.1, to take such measures as may be reasonable for the purpose of averting or minimizing such loss, 16.2, and the underwriters will, in addition to any loss recoverable hereunder, reimburse the assured for any charges properly and reasonably incurred in pursuance of these duties, unquote. Both the Masefield case and the Royal Boscalis judgments support the contention by contributing to a ransom payment, the insured is only ensuring the safe return of the goods and it would be hence recoverable as sue and labor expenses. Of course, if the ransom contribution exceeds the value of the cargo, then it would become unreasonable and hence not recoverable.
So, sir, just double clicking on this point further, another question which arises is whether cargo interest can be found to be in breach of the duty of assured clause by not agreeing to pay or contribute to ransom, and can their claim be thereby prejudiced?
In my opinion, a failure to pay ransom in such circumstances is unlikely to preclude any claim that the cargo owner might have under their policy, since the proximate cause of the claim would be held to be piracy and not the failure to pay ransom. Though it is recoverable under the duty of the assured clause as sue and labor expenses, due to considerations of public interest, it would be very difficult for any court to hold that any cargo owner or insured has an obligation to pay ransom.
So, sir, can the contribution to payment of ransom be recovered under any other head in a marine policy apart from sue and labor expenses?
Yes. If the ship owner declares general average and the insured is required to contribute to ransom, such contributions can be recovered as GA expenses under a policy which covers the risk of piracy. To understand the issue better, let us have a look at Section 66, subsection 2 of the Marine Insurance Act 1906, corresponding to the same section in the Marine Insurance Act 1963. This section states that there is a general average act where any extraordinary sacrifice or expenditure is voluntarily and reasonably made or incurred in time of peril for the purpose of preserving the property imperiled in common adventure. Now, that means that where the ship owner has declared GA and the insured is required to contribute to ransom, we can very well observe that ransom payment qualifies as an extraordinary expenditure voluntarily incurred to save property imperiled in common adventure. Hence, all the boxes being ticked, such contributions should be recoverable as GA expenses under a policy which covers the risk of piracy. The only debate here could be on the element of subjectivity brought in by the word reasonable in the general average definition. In my opinion, reasonableness should be considered as dependent on the facts of each case. This is based on the logic enunciated in Section 88 of the UK Marine Insurance Act 1906, corresponding to Section 87 of the Marine Insurance Act 1963, where in reference to reasonable time, reasonable diligence and reasonable premium, it is laid down that the question of what is reasonable is a question of fact. Now, talking of general average, one is reminded of the Longchamp case decided in 2017, wherein the UK Supreme Court considered in the context of general average under the York-Antwerp Rules 1974, the place of ransom payments and associated expenses incurred by the ship owner during the extended period of negotiation over the ransom. While it was an accepted position by both the parties in the case that the ransom payments were part of GA under Rule A of the York-Antwerp Rules, This gives legitimacy to ransom payments, incidentally, as being both legal and not against public policy. However, a slightly different issue was being debated by the UK Supreme Court in this case, that of whether daily operating expenses incurred whilst the amount of the ransom was being negotiated downwards should be allowed in general average in addition to the ransom. The Supreme Court ultimately held that they may be so allowed under Rule F of the York and Toep rules as substituted expenses, which, while not themselves qualifying as general average expense under the rules, nevertheless result in the avoidance of such general average expense.
So, sir, in conclusion, two thoughts emerge. One, that the line between piracy, terrorism, and other acts of violence are delineated basically on intent, and in actual practice, it may be very difficult to separate them. And secondly, the Messfield decision, and it makes it difficult for the cargo interest as there is no iota of doubt that the detainment of goods by pirate come at a cost to them which does not seem to be covered by an all-risk marine policy.
Both observations by you are actually spot on. The lines between piracy and terrorism may be blurred at times, as motive is difficult to ascertain, particularly immediately following an event. As noted earlier, pirates are inherently different from terrorists. Usually they operate on a local scale and are averse to killing or getting killed themselves. Terrorist organizations, on the other hand, operate on a global scale and often aim to kill for publicity. They are also prone to risk their own lives, as we can see from the spate of a suicide attack. Coming to the decision in Masefield, I would venture to say that it does leave a lot of uncertainty for the cargo owner, with several unanswered questions such as how long to wait and see, how to know when there is a total loss in case of piracy, and how to establish that there is no hope of recovery of the consignment. One can safely opine that the present cargo clauses are primarily designed to cover physical loss or damage to the cargo, and cargo owners will remain at a distinct disadvantage in such situations involving capture of their goods by piracy, unless insurers recognize this area of concern and devise a cover for losses following such detention.
So, even though the marine insurance is probably the oldest form of insurance, we can say that there is still room for product development.
I think insurance, being a dynamic subject, has to respond to changing situations and requirements of the trade and requirements of their insureds. So there have been a lot of changes in insurance policies over the years, in insurance covers over the years, even in marine insurance. And we may see even the loss to cargo owners being covered in future.
Right, sir. So with this, we have reached the end of today's episode where we discuss some acts of violence incidental to maritime adventure. We primarily focused on piracy and terrorism, but there can be many other forms of violence on sea, and that warrants a separate dedicated discussion. Hope you liked this episode, and let us know through your comments and suggestions if you guys want to know more about other forms of acts of violence on sea or any other topic. A big thanks to Basudev sir for such an interesting episode with so many interesting case law and anecdotes. Any last comments, sir?
Thank you, and hope to again come back and discuss some other interesting aspect of marine insurance in the future.
Thank you, sir. So that wraps it up. Once again, thank you for listening to our episode. Keep supporting us and keep dissecting whatever makes you curious.